Hello, my name is Mark Reed. I'm a solicitor at Lawdit Solicitors. I have been asked to come in and do a podcast today, which is a relatively short one. It'll be succinct, but it's quite important for our listeners to bear in mind regarding lasting power of attorneys. Now, of course, I'm going to open up to the floor. I have Ellis and I have Sam here. Do either of you know or have a lasting power of attorney? Moving forward, by the way, I won't call them lasting power of attorneys. I shall call them LPAs.
No to both questions, which is probably bad as solicitors. I don't have a lasting power of attorney, and I don't know anyone that does, I don't think. Sam?
I do not have an LPA, and I don't believe my grandparents do either, to be honest. So no, I don't know.
Okay.
No.
But do you accept?
Starting well.
But do you accept the importance of having one, or the reason why that you haven't got one is because you don't accept that it's an important thing, or maybe I could educate you?
I think it's a very important thing, and I think it's one of those situations that probably a lot of people are in. They know it's important, but they probably think that actually it's not important to them at this time of their life. And unfortunately, sometimes circumstances arise where it becomes too late.
Absolutely. So I'm just going to give you a bit of a personal insight here as to the reason why I personally do have a lasting power of attorney, and so does my wife, because about 2 and a bit years ago I had just randomly collapsed and just went into what was like a seizure state. And the concern, once I actually came out and everything was fine and there was nothing the matter with me, I was dehydrated apparently, but it made me go, goodness me, because I was having these like epileptic type seizures, if that had caused me to lose the mental capacity to make decisions for myself, what would happen? What would that mean for my wife? What difficulty would that have? Would that leave her in? And certainly if she's also having to deal and adjust with the changes in our home life, if suddenly whatever the cause was of me having these seizures was worse than it was, and I was no longer in a position to be able to make decisions. So it suddenly became very apparent to me, and I'm not overly old. I know some people think that you know it's only old people that need a lasting power of attorney. Well, I can tell you now that is not the case. Everybody should really consider reading into lasting power of attorneys and the reasons why. So there we are. A lasting power of attorney. Oh, sorry, I said I was going to call them LPAs moving forward, didn't I? An LPA. You have 2 applications. The Office of Public Guardian will be the organisation that's going to be dealing with it. The 2 applications that you would consider making are health and welfare and property and finance. They're split into 2 because some people consider themselves as not really needing one of those 2, so they end up just going with just having one of them. The person that is having the LPA drafted is known as the donor. Okay? The attorneys are those people that you would ask, or because obviously you need to ask them first that they'd be willing to do so, that you would be handing over the power to be able to deal with your affairs as the donor if you suddenly lost the mental capacity. Why is this important? Well, actually, now I'm going to ask you, why do you think it's important, Ellis, to have a health and welfare LPA if suddenly you lost the mental capacity?
Well, I can, again, bring in a personal sort of story here. Someone that was very close to me was in her early 50s and developed a brain tumour, very serious brain tumour that is incurable, and she deteriorated very quickly and lost mental capacity very quickly, and it became very difficult. She didn't have an LPA in place. It became very difficult for her children to make health and sort of medical decisions for her to allow her to be cared for moving forward without having that in place. There is a lot of people think, it's for sort of like you say, when you get really old and potentially certain sort of conditions come into play, but actually you can have an accident, you could develop something very quickly, and there are so many medical decisions to be made and so many different avenues those medical decisions can go down that may or may not be within your preference, and actually the doctors, while they're doing what's in your best interest, they may not be choosing that option that you would have preferred.
Okay, so I'm now just going to step in with the example there. If you've got an individual that sadly loses the mental capacity to make certain decisions, those decisions need to be handed to someone that is close to you, that you know that you would have trusted, but you haven't already got the LPA in place. So what can be done? Well, emergency provisions can be made. You apply to the Court of Protection, okay, for an emergency power of attorney. That is fast-tracked. You have to be able to give evidence and reasoning as to what's happened, why that person has lost their mental capacity, and what rights you have to be the person to be considered as the attorney in control. It's obviously something that people don't want to have to do. It is very stressful, and in actual fact, very expensive. It's just so much easier to have it all in place, so that essentially you, as the attorney, have got the paperwork, the certification to say the minute that the donor, your loved one, has suddenly lost the mental capacity, you're able to step in and deal with things.
It's seamless. The Court of Protection side of things stalls everything. So a lot of the time you don't have time for these things to be stalled, but it makes the process very sort of difficult and not seamless in getting that person the help and the decisions made that would be best.
Now, of course, you know, when it comes to health and welfare, put my teeth back in, there are very serious decisions which need to be made at times, and when you look through the application process, there is a tick box which needs to be taken very, very seriously as to from the donor's perspective as to life support and having the power to be able to make decisions in terms of turning off a life support machine. I'm going to leave it there because that just is something just to really think strongly about, that you might not even think would be part of your life or decisions that you would be asking your attorneys to make. Okay. So moving on, now you can see that initial sort of position there with a health and welfare application that's made. That's the first application. The second application is, as I say, property and finance. Now, this one I find quite interesting because, and I'm going to bring Sam into this here because you mentioned on a previous podcast, Sam, that we had been discussing stuff to do with marriage and rights that people have when they're married. Now, if we're considering the finances and suddenly someone being in control of your finances, Sam, what is it we're talking about when we say someone else's finances?
We're talking about their managing the way they utilise their income, or perhaps it might be a pension, and talking about whether they do or do not purchase certain things. You've got what happens with property. You have some people have investment accounts, pensions.
But of course, everything that you're saying there would be, if we've got stuff that's in joint names, would you need to be able to have a lasting power of attorney to be able to make decisions of something, let's say, that's in a joint account, like a joint bank account?
Well, no, if it's in a joint bank account, the other joint owner will still be able to control it in the same way you would be able to control it.
So you're talking about individual accounts or ISAs or stocks and share accounts, as you say, pension. You know, if something's going into an account and you can't access it, it could be a bank account that's an individual. As it stands at the moment, of course, you as the spouse are not able to touch anything individual because you don't have the legal right to do so. That's correct, isn't it?
That's correct.
Yeah. Okay. So therefore, thanks, Sam. So therefore, in terms of the property and finances, we really do urge you to try and get your head around the severity of someone losing the mental capacity and you suddenly being told, I'm sorry, you cannot access this, that and the other. It really could be something with paying bills. You can't access this because you don't have the legal right to do so. Go away and get an emergency power of attorney over the finances and we will reconsider our position. So that could be you walking into a bank. Again, as Ellis said, seamless. You've suddenly got this certificate. You can walk straight into a bank and say, unfortunately, here's a doctor's letter that clearly states that my loved one has lost the mental capacity. We're all in a really bad state at the moment. We're hoping that person regains the mental capacity, but at the moment they're not. They've been in a terrible accident. I need to be able to control all of their finances until one day, hopefully, they will suddenly be able to look after it again themselves. No problem, says the bank. We can give you access to this, that, and the other. You can make these payments. Mustn't be taken lightly, though. It's a very big decision, you know, in terms of the way the law looks upon an attorney. You have very serious responsibilities. Okay, so when you as the donor are thinking about the who to have as an attorney, really think wisely. You know, there's no point, certainly with their financing, if you've got someone that is so terrible with money, they're constantly having to pawn their watch or something every month because they don't think ahead. Do you really want them in control of your finances until you've got the capacity back again? In terms of the drafting aspect of things, so this is something we do. Some people are more than happy to actually draft their own through the portal. But they, of course, need a certificate provider. I say, of course, I'm about to explain the reasons why, but you have to have a certificate provider that can go through the application to make sure that they sign off. What is it they're signing off, though? They're signing off that all parties have the mental capacity under the, what's the name of the Act, Sam?
Mental Capacity Act 2005.
Well done. The Mental Capacity Act of 2005 is quite honestly telling you that if you, as the certificate provider, are going round to someone's property to sit with them, or they come into the office, you need to ensure that they understand fully what it is that they're doing. Now, for you to understand that they know exactly what it is that they're doing, you need to confirm that they have got the mental capacity. And if they do not have the mental capacity, then you obviously cannot proceed with signing off as a certificate provider so that application can be lodged with the Office of Public Guardian. Okay, very serious. So that's why we tend to find that people come around for some advice, sit in our office and say, I've been hearing a lot about these lasting power of attorneys, this and that and the other happened to my friend, I'd like to make them, please. I'd like to make them for my parents. My parents have authorised me to come and see you. Okay, that's fine. And then we go through the situation in detail, and I then have to ask the question, so do you, I take it your parents, when I go and meet them, they have got the mental capacity? Oh no, my father hasn't, or my mother hasn't, because they've had this accident, this, that and the other. Well, then we need to get emergency provisions with the Court of Protection, okay, because I can't go around there and explain to someone that doesn't understand what it is that I'm saying to them. The reason why is because they have to sign, and it has to be witnessed, and I have to be the certificate provider to say that everyone understands fully what this means. So if it's quite obvious that they're signing something, they don't know what they're signing, they should not be signing it. Okay? It's a very serious thing. Currently, price-wise, in terms of the application fee that is paid when the application is lodged, each application, note there are two, as I say, each application is £82. Okay, so for the pair of applications, that would be £164. Plus any legal fees for doing the drafting and, of course, signing off the certificate provider points of information. Now, that isn't something I'll go into now. That's for something for once we've actually had the discussion and you've phoned us up, I can go through that with you and one of my team. But please don't hold off, because suddenly what's going to happen is you might not have a will, you might not have a power of attorney, and so on and so on, because you think that you don't need to. Maybe it's because you feel that you're too young, you don't need to worry about that yet. Maybe it's because you don't fully understand it and feel that because you don't understand it, obviously it isn't that important, because not everyone's shouting about it. But believe me, it is important. Even if you try and do it yourself, go and get the LPAs. Guys, does that now make sense why it is that you would want to have an LPA?
It does indeed.
And now I'm going to ask the question to you and you, Ellis and Sam. Following this podcast, are you both going to making sure that you get your LPAs done?
Yes, absolutely.
Of course. Excellent stuff. Okay, if anyone has any further information that they need, if I've missed anything out or you need clarification on anything, do give us a call, 02380 235 979. Ask for me. My name's Mark Reed. Alternatively, you can send an email to info@lawdit.co.uk. Thank you very much. Take care. Bye-bye.